Okay. I don't see any private attorneys on the line, so he may need your assistance.
Okay.
Okay, who do we have, sir? Who is in the chair?
This is position number 6, Mr. Sanders. This is Ms. McLeod's case.
Thank you. Mr. Sanders, your case is 24 CR 006621. Why you're charged with violating a family violence protective order. Do you understand your rights today? All right. Mr. Howard?
24 total. 2020 driving without a valid license dismissed. 2013 probation. 2010 trespass conviction. 08 possession of marijuana, tampering with evidence conviction.
All right. Thank you. Ms. Reddick, please proceed.
Your Honor, on September 20th, 2024, at 1975 Plaza Lane Southwest in Atlanta, which is Fulton County, officers responded to the above location. They met with our victim, Ms. Sheila McCullough, who indicated she may be online today. She provided the officers a copy of a protective order signed out of Superior Court in Fulton County to serve on the defendant. Officers served the TPO on the defendant, and as part of the order, he was required to leave the residence. Officers asked the defendant to leave. He told them that he would not. Again, officers advised the defendant he needed to leave. He said he had no place to go. Officers provided the defendant with a list of shelters he could go to. Defendant continued to refuse to leave, and officers placed him into custody and brought him down to the Fulton County Jail. What's important to know, Your Honor, is that the defendant and the victim share a child together. They were living together at the time. There has been a history of domestic violence between the two of them. They had a previous TPO around approximately 2018. They are now going through a divorce. The defendant is very afraid for her safety. He has at other times refused to stay away from the residence. And so at this time, Your Honor, we understand because of this is a misdemeanor. We cannot ask for a no bond. What we would be asking for is a $5,000 surety bond. No further contact with the victim. Stay away from the address. No alcohol, drugs, and weapons while out on bond.
Thank you. And Ms. McCullough, are you present and wish to make a statement? If so, please turn on your camera, raise your right hand. It says she's logging in. Is she present? We'll give it like one more minute. All right. In the meantime, Ms. McLeod, please proceed.
Yes, Your Honor. My client is 51 years old. I was able to speak with him for some time today. He tells me that the parties have been married for approximately 12 years. They share a 4-year-old child, and they also had another child who died. He tells me that he's always worked very hard and provided for his family. But in the recent past, he had become ill and was unable to work. And because of that, the relationship has deteriorated because his wife was sort of taking the attitude that since he's not providing, he can be treated anyway. He tells me that she's been seeing someone else, which he's aware of, and all of that. He said he did not know that the TPO was in place. And when the police officers came, he was surprised and he told them that, he has nowhere else to go, so they could take him to jail. I would ask, my client is not working, so I would ask the court to consider giving him a signature bond. I know the state has said that he has a history of violence, but I did not hear any convictions whatsoever for any kind of violence. I would ask the court to consider giving my client a signature bond because he cannot pay for bond because he has not been working for a while. We understand that there is now a TPO in place, and he understands that now. But based on my discussion with him, he did not understand that there was a TPO in place. That when the police officers came to the house also, and he understood there was a TPO. I would also ask for at least a one-time police escort so he can get some things to take with him. Nothing further, Your Honor.
All right. Is Ms. McCullough here now?
I don't see her.
I've sounded twice. All right. Defendant is going to receive a $1,500 surety bond. He's to have no contact with the alleged victim and stay away from that residence. He can return one time with a member of law enforcement to get any items, and he's to have no alcohol, no drugs, no weapons. And he is going to the SAP calendar on October the 3rd. All right. Anything additional from the state of the defense?
Nothing further, Your Honor. Thank you very much. That concludes my business before the court today. May I be excused?
Yes, you may. Take care. Have a good weekend, Ms. McLeod. Bye-bye.
You too, Your Honor.
All right. Who do we have next?
We have position number 5, Mr. Ponce.
All right. Did we clarify whether he had private attorney coming?
It's a private attorney's on.
Okay. Maybe my screen didn't scramble. Who represents Mr.
Good
Pond?
morning. Good morning, Your Honor. This is Javier Benavides on behalf of Mr. Gustavo Ponce.
Okay, thank you. Good morning, Mr. Ponce. Your case is 24 CR 006617E. You're charged with battery, family violence, simple battery, family violence, and obstruction. Do you understand your rights today? All right, I have that this is first arrest, so we'll go to Mr. Riddick. Is that correct, Ms. Howard?
Yes.
All right, thank you.
Your Honor, on September 20th, 2024, at 114 Preston Woods Trail in Sandy Springs, Fulton County, law enforcement responded to above location. They met with several witnesses standing in the parking lot of this apartment complex. The witnesses advised law enforcement that they saw our victim, Ms. Carla Ponce, trying to escape a black SUV that was being driven by the defendant. At one point, she was successful in getting out. The defendant pursued her, pulled her hair, and pushed her back into the vehicle. She again tried to escape a couple of times. She was finally able to escape the SUV, went running into the apartment complex where the witnesses lost sight of her. Law enforcement ran the license plate for the SUV. It came back to Gustavo Ponce. They gave the apartment number. When law enforcement presented to the apartment, Mr. Ponce yelled through the door that they would need a search warrant to get in. Officers saw Carla Ponce looking through the window, appearing to be scared and frightened. They assisted her in escaping the apartment. After some time, Gustavo Ponce opened the door and engaged law enforcement. When he came out, he indicated that the bruising to the victim's right eye and left side of her face was a result of her falling. Your Honor is correct that there is no prior arrest for this defendant. We do have a concern about witness intimidation and a danger to the community. They have been married approximately 3 years. Although Ms. Ponce has asked, based on the information from the witnesses we would have, that on the battery family violence, the charge, we have $3,500 surety bond. We were asking, contrary to Ms. Ponce's request, no further contact with the victim, that Mr. Ponce stay away from the incident location. While on bond, he complete an anger management class. He has no drugs, alcohol, or weapons. On the simple battery, which is for the battery was for the bruising to her face, the simple battery is for the pulling of the hair. We would ask for a $1,500 surety bond, and for the obstruction of law enforcement and refusing to allow her to leave the apartment and forcing her to have to be assisted to get out, we're asked for a $1,000 bond. And I just need the court to be clear. Ms. Ponce has asked us to allow contact. The state is making the request for no further contact.
All right, Ms. Ponce, I see you online. Please raise your right hand if you'd like to make a statement.
She advised us she did not want to make a statement.
She does not want to make a statement. I'm still going to ask, if you'd like to make a statement, you are free to do so. You are not required to. If you wish to, please raise your right hand and unmute your screen. All right. Hearing none, Mr. Benavides, please proceed.
Yes, Your Honor. Good morning. Oh, good afternoon. Your Honor, my understanding is my client, the state is correct. My client has no priors, no convictions. He does have employment. He has a child here who I believe is 10 years old. So there's no reason for him to leave the state of Georgia, Your Honor, and be on flee the jurisdiction of the court. So the court can actually, I can reassure to the court that he would actually comply with appearing to every single court hearing in these proceedings. So that factor right now, right there, Your Honor, is absolutely, secure. There's no issue with that. As far as the danger to the community, Your Honor, I mean, I understand the state has actually, stated what is in the law, but has not provided any sort of evidence that would actually, what do you say, substantiate what is being said, that he's a danger to the community. There's an issue, there's a specific allegation, Your Honor, this man has been living in this country for more than 25 years. He's never had any sort of altercation or incident with the law enforcement. He's never been arrested in his life. He does not have a problem with drugs, alcohol, or anything like that. This is a very unfortunate situation that would actually need to be clarified down the road when this case comes to a trial or any sort of resolution. But I don't believe, Your Honor, my client is a danger to the community in any way, shape, or form. I think the court should actually weigh the fact that the victim herself indicates that there's no issue with her husband. They've been together for 3 years. They know each other for longer than 3 years. They were dating prior to getting married. Okay, he is a family man. He is a great stepfather of the victim's son, who is, I believe, 11 or 12 years old. He's been the provider, the breadwinner for this family. So I think that, Your Honor, it is absolutely disproportionate to give him a $6,000 bond on a domestic violence case, Your Honor. He hasn't committed a felony. I mean, I see felonies that go for that much. I understand there's three allegations that are absolutely serious, but I don't really think that he has that type of money to begin with, and he needs to go back to work. Okay, Your Honor, as far as intimidating witnesses, there's no indication that he has actually done or said anything that would actually intimidate the witnesses in this case. In fact, he doesn't even know the identities of the people who call 911. And there's no evidence whatsoever from the victim herself who has spoken with the state indicating that she's being asked to change her story, to tell the judge, the court, something that is not accurate, that is not the truth. And as far as tampering with evidence, Your Honor, I mean, I don't see the ability my client would actually have to tamper with any evidence. At this point, we don't even know what's in evidence at this point. So, Your Honor, I believe, based on my experience in this type of cases, Your Honor, I think the $1,000 bond on the battery domestic violence charges, I think would be appropriate, Your Honor. For the other two charges, I believe, maybe $500 each, so totaling a $2,000 bond, which this man would be able to afford to pay. And once again, Your Honor, the victim says she's been living with this man for 3 years. I understand that there's something that has happened that needs to be cured, that needs to be dealt with. And my client absolutely, I think the specific conditions as far as the bond conditions can actually cure. He can actually be asked to complete. I already had a conversation with him. He's willing to complete the FIP, which is a more stringent, a more comprehensive program that what the state is offering at this point. He is willing, as well as the victim, to go to family therapy, which is, I think, more appropriate, Your Honor. So the court can actually put on the order that they're going to do family. Of course, the victim can. I understand that the court does not have jurisdiction to force the victim to go to therapy, but my client does. He wants to fix this. He wants to work on this. This is something that has happened once in a blue moon. There's never been any sort of phone call to 911 among these parties. So, Your Honor, based on the facts alone, Your Honor, my understanding is that I actually forgot to touch on this point. My understanding is that there was some sort of altercation between the two, and as a result of that, Miss Ponce got a little bit of a bruise. But it wasn't that my client inflicted the injury. It was more of an accidental inappropriate contact they both of them had. My client did not actually punch her in the face or intentionally inflicted a wound on her. And that has actually been said to me by both the victim and my client. So, Your Honor, I respectfully request, Your Honor, the defense and a $2,000 bond, and with the specific conditions that would actually address the actual issues. That's all, Your Honor. Thank you.
All right. In light of the information before me, defendant will receive a $5,000 signature bond through pretrial services at level 1. The breakdown is as follows: $3,000 on the battery and $1,000 on each of the remaining charges. For now, he's to have no contact with the alleged victim. He can communicate through a third party to coordinate the transfer of any children. He can return to the location one time with a member of law enforcement to get any items. Otherwise, he is to stay away, and he is to have no alcohol, no drugs, or weapons. As a reminder, contact can be revisited at a later date.
Thank you, Your Honor.
All right. Best of luck to you, sir. That concludes your case, and best of luck to you, ma'am, as well. And does that conclude your business today, counsel?
That concludes my business, Your Honor. Thank you. May I be please excused?
Yes. Take care. Have a good day.
Bye-bye.
Next, we have position number 2, Mr. Campbell.
All right. Good afternoon, Mr. Campbell. Your case number is 20. Oh, that's not it. I apologize. Hold on. Your case is 24CR00661. 24CR0066191Y. You're charged with giving false information. Do you understand your rights today? Is that a yes? All right, Mr. Howard.
Fourth arrest, 2023 FTA on probation out of Fayette County, Rico. He got a Fayette County hold.
Okay.
All right.
All right, thank you. Mr. Pierre Thomas, please proceed.
Good afternoon, Your Honor. Your Honor, the allegation is that on the 19th of this month, 2024, obviously, the defendant called 911 to report a larceny that had taken place where he was listed as the victim. When asked for identification, he stated that he did not have any, but provided the name of Martinez, Martinez, Frost, Frost, with a date of birth listed as being in 2001, with also different date and month from his that was out of Tennessee. When the officer ran it, it stated that there was no person in Tennessee by that name. The defendant also provided a false social security number that returned to an unknown female out of Tennessee. The request from the state is a signature bond through the jail, no alcohol, drugs, or weapons, and that he be transferred to the hold.
I was going to do that myself. Any objection to that, Mr. Bartels?
None whatsoever, Your Honor. We would ask that for that as well.
All right, defendant will receive a $2,000 SLB through the jail. He's to have no alcohol, drugs, or weapons, and he's to be transferred to that Fayette County hold. Best of luck to you, sir. Who do we have next?
Thank you, Judge.
Position number 7, Mr. Shadrick.
Mrs. Shadrick, your case is 24CR00663A. You are charged with battery and simple battery. Do you understand your rights today?
I do.
All right, thank you. Mr. Howard, can I have his
2024 case for simple battery, 2 counts. That's open out of state court.
Oh, wait, I'm so sorry. For this particular case, I was going to ask for a breakout.
Okay, can we take Mr. Shadrick last then?
No problem. You can have a seat back in the back. At the end.
I apologize, Your Honor. I didn't get the calendar emailed to me until the last minute, so I hadn't transferred that note over.
Okay.
Next, we can go to position number 8, Mr. Thurman.
All right, Mr. Thurman, good afternoon. Your case is 24CR00664E. You're charged with 2 counts of battery, 2 counts of simple battery. Do you understand your rights today?
Yes, ma'am.
Thank you, Mr. Howard.
This is third arrest this month. He was arrested on the 17th, terrorist threats, battery, pointing, aiming pistol at another, driving without a valid license. That's all.
Okay, thank you, Ms. Reddick.
Your Honor, I'm sorry to interrupt, but I believe that's Ms. Bronstein's case as well.
Yes.
I think she's in a breakout. Oh, you're there.
Oh, yeah,
I
I'm
thought
here.
you were in breakout. All right.
We
sorry.
haven't done it yet.
Okay.
All right, Ms. Reddick.
Your Honor, this Incident is alleged to have occurred on June 30th, 2024. Incident location is 3136 East Point Street, East Point, Georgia, Fulton County. Officers responded to the above location. They met with the victim, Mr. Dante Vigil, Vigal, who advised law enforcement that when he went outside the residence, he was struck in the face by Kiera, Kierra Mumford, before being kicked and punched repeatedly by the defendant, Miss Mumford, and several others. Officers also met with Miss Diamond, Dymond, Thurman, who is the sister of the defendant, who advised that the defendant, along with his girlfriend and several other family members, came to her home in East Point, attacked her boyfriend, Mr. Vigil, and when she tried to break up the fight, she was then attacked by the defendant as well as others. Officers noted that Ms. Thurman had a visible scratch on her leg. She also complained on scene of a headache. They also noted lacerations and bruisings to the face of Mr. Vigil. The attack on Ms. Thurman and Mr. Vigil was witnessed by a third party. Your Honor, as pretrial services told you, this defendant was arrested earlier this month on terroristic threats, battery, pointing a gun at another. That case is still pending in DeKalb County. He was currently on bond from that case when he got this case. There is a concern for a risk of intimidation, just in light of the charges he has out of DeKalb, as well as the relationship because Ms. Diamond is his sister. State's recommendation is a total bond of $8,000, $2,500 surety bond on each count of battery, no further contact with either of the victims, stay away from the home in East Point, 1 day anger awareness, no alcohol, drugs, or weapons while out on bond. We would also be asking for a $1,500 surety bond on each count of simple battery with the same conditions, Judge.
All right, and I'm sorry, the victim's name again is, so I can sound.
There's two of them, Diamond, Dymond, Thurman, Thurman, and then Dante, Dante, Vigil, Vigal.
Is Ms. Thurman or Mr. Vigil present on the Zoom conference and wish to make a statement? Hearing, seeing none, Ms. Bronstein.
Thank you, Your Honor. Before I let the court know my planned remarks, I do just want to clarify a couple things. One, he didn't get this case while he was out on bond for the other one, is my understanding, because he just got out on bond for the DeKalb case, and this the incident date for this case is back in June. And also it's my understanding that Ms. Thurman is Mr. Thurman's cousin, not sister. Is that correct, Mr. Thurman? Okay, yeah, it's his cousin. So to let the court know, Mr. Thurman is from Atlanta, born and raised. He is 18 years old. He went to the 11th grade. He has 1 year left in high school. He lives with his mom, his brothers, his girlfriend. He has twin 1-year-old babies. His grandmother and uncle do also live nearby. As far as, and he is also working for Amazon up in Marietta. As far as this case goes, he does say that Mr. Dante texted one of his co-defendants to come fight him, that Mr. Thurman actually has a video of the whole thing, that he was not engaged in any of the fighting. So clearly, I told him to make sure that he saves his video and gives that to my office so that we can present that to the state, because that's clearly very different than what the complaining witnesses and the other witnesses are saying. So due to these, we are asking that the court consider a signature bond. No contact is fine. We understand that. And to be fair, I think it's best that they don't have any contact right now while the case is pending. Either a signature bond or a very low bond.
All right, defendant is going to receive a $2,500 surety bond broken down as follows: $1,000 for each count of battery and $250 for each count of simple battery to get that total of $2,500. He is to have no contact whatsoever with Ms. Thurman or Mr. Vigil. Stay away from that incident location. Have no alcohol, no drugs, no weapons. That's a condition. and he will be going to all purpose on October 3rd, whereby aspects of the case can be revisited.
Thank you, Your
All
Honor.
right. Best of luck to you, sir. Who do we have next?
Next, we have position number 3, Mr. Davis.
Mr. Davis, good afternoon. Your case number is 24 CR 006620. While you're charged with obstruction, battery, family violence, and 2 counts of cruelty. Do you understand your rights today?
Yes.
All right. Cruelty in the third, let me be clear. Mr. Howard, please give me the history.
39, 2020 domestic battery, 05 battery conviction, 09 battery, stricken off with leave to reinstate, 2014 resisting peace officer conviction, 2016 and 17 trespass conviction. That's all.
All right. Thank you. Mr. Pierre Thomas, please proceed.
Your Honor, brief facts of the case is that on September 19, 2024, officers were dispatched to 2265 Perry Boulevard, Northwest Atlanta, Georgia, here in Fulton County, Georgia, on a physical dispute call. The defendant stated that he got into a verbal dispute with a significant other, the victim, but did not make physical contact with the victim. The victim was actually located at Fire Station 28, which is far away, a separate location from the incident. Due to her being in fear, the victim stated that she was outside on the patio when a dispute over the discipline of their male child, their juvenile male child, took place. The victim stated that she pulled the male child's arm to attempt to pull him away from the defendant. The victim stated that the defendant then pushed her off the male child and she fell back. The victim's other daughter, we're going to refer to her as initial CD, advised that her mother was able to get her brother away from the defendant, who is that person's father. She stated her father, the defendant, said he don't you ever effing touch me like that again. She stated that her father then approached her mother and began to strike her with a closed fist. She also stated that her mother fell to the floor and her father began to kick her mother. She stated that her and her sister, also a separate person but initials C and D, covered her mother to protect her from being kicked by their father. She stated that her father then stopped kicking her mother, and the mother walked away. The victim, the mother, stated that once she was able to stand up, she and the children got into a vehicle and drove to Fire Station 28 and waited for the police. The victim sustained a cut to the inside of her lip, bruising, swelling to the left side of her face, and a knot on the upper part of her head. The defendant voluntarily stated that he was under the influence of alcohol during the incident and to which point he also ran from the officer when the officer initially approached. We were fortunate enough to speak to the victim in this case. The victim, the adult victim, is Ikna, I-K-N-A, Wilson, W-I-L-S-O-N. She advised that the facts as stated in the latter part of the warrant were correct. She does, however, state that she wants contact with the defendant, and that she'd wish for him to return to the residence. However, the state is concerned, as this matter happened just what appears to be 2 days ago. The request from the state is, and this is in lieu of us hearing, or in light of us hearing, the 2020 conviction for domestic battery. There's also another 2020 arrest for domestic battery, 2016 arrest for domestic battery, and a 2014 aggravated battery arrest on a police officer. So the state's request is a $3,500 surety bond, no alcohol, drugs, or weapons, the completion of an anger management course, a stay away from that incident location, and a no contact with the victim. And if we could sound for the victim in accordance with Marcy's law, that'd be greatly appreciated. But there's nothing further to add from the state at this time.
All right. Is the Ms. Wilson present on the Zoom conference and wishes to make a statement? Hearing none, Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Davis about this case and about his situation. He does deny a number of the allegations that are in the affidavit. He said there was a verbal argument, but that there was no physical contact. I believe he stated the officer, he said that both parties had been drinking, but drinking is not necessarily the same as being under the influence. I don't believe he made that actual admission. But my client, he does have ties to the community. He is employed full-time at In-Town Designs. He does work and polishing on granite for roofs and floors and countertops. He does have relatives in the metro Atlanta area. He's been employed full-time at his job for quite some time, so he does have ties to the community. It does appear from what the state is saying that Ms. Wilson is okay with no further violent contact. We would ask the court to consider that, but if the court's inclined to do no further contact, my client has told me that they both live in separate residences. So that's not an issue in terms of either of them, or in terms of him having to find a new place to stay. They do have 3 children together, so if there is no contact, we would just ask that he be able to have contact with a third party in order to visit his children. And it looks from the paperwork that he would qualify for a UJR level 3 signature bond. We would ask the court to consider that. But if the court is not inclined to grant that, we would ask for a $2,500 total bond. That would be $1,000 on the battery and then $500 on each of the other 3 charges. And that's it for now.
I have 4 charges, Mr. Bartell. Let's make
Yes,
sure.
ma'am. We
Okay,
would
make
ask
sure.
for 1,000 plus 500 on the other 3. So that would be 2,500 total.
Okay,
If the court's not inclined to grant a signature.
okay, understood. Give me 1 second.
Yes, ma'am.
Okay. Defendant is going to receive a $2,500 surety bond broken down as follows: 500 on the obstruction, 1,500 on the second. I'm so bad at math. Nope, that's not gonna get it. Okay, so it's gonna be 1,000 on the battery and 500 on each of the remaining charges to get us to that 2,500. He's to have no contact with the alleged victim. He can coordinate transfer of the children through a third party. And additionally, he stay away from that location, have no alcohol, drugs, or weapons. He's going to all purpose as well on the third, whereby aspects of the case can be revisited.
Just to clarify, Your Honor, I believe this location is his address.
He doesn't have to stay away from his home. He needs to just stay away from where she resides.
Okay, all right. You understand that, Mr. Davis? Okay, all right, very well. Thank you, Judge.
Judge, may I ask how much would I need to post to be free?
Most bonding companies, Mr. Davis, they charge about 10 to 12%.
All right. Best of luck to you, Mr. Davis.
Huh?
I said best of luck to you. Mr. Bartels just explained it's a percentage. It depends on the bonding company that you use. But you will not have to post the full 2,500, okay?
Thank you, Judge.
Next, we have position number 1, Mr. Anderson.
All right, Mr. Anderson, your case is 24 CR 006618J. You're charged with 2 counts of theft by taking. Do you understand your rights today? All right, Mr. Howard.
8th adult arrest, 2023 theft by taking. That's open. 23 CP 218635. Got a theft by receiving 2 counts out of Riverdale. 2019 sale of marijuana. 2017 theft by taking. Now he should have gone to felony court earlier. I don't know what the bond was though.
All right, Mr. Pierre Thomas.
Now, the brief facts of the case is that on May 18, 2008, a STIHL chop saw valued at approximately $1,400 was taken from a construction site at Georgia State University Convocation Center located at 455 Capitol Avenue, Southeast Atlanta, Georgia, 30312 here in Fulton County, Georgia. Surveillance footage revealed a Nissan Sentra drove onto the rear lot and parked near the gate of the construction site. A male wearing a black hoodie and blue jeans stepped out of the passenger side of the vehicle, walked onto the construction site, grabbed the chop saw, and placed it in the trunk of the vehicle. Atlanta police advised that they arrested 2 black males, the other black male listed as KASKIUS, last name Battle, and the defendant the very next day, which would have been May 19th, 2023, for the theft of another chop saw, the same type, at the location of 550 Federal Terrace, Southeast Atlanta, Georgia, in Fulton County, Georgia. Those suspects were apprehended during a traffic stop at which point they were driving the same vehicle which bear the same license tag related to the theft that happened at the earlier location. Also, the defendant was wearing the same clothes. Your Honor, the state's request in this matter, and that's in I guess in light of his lengthy theft-related history. I see a 2013 burglary, a 2015, 2 counts of theft by receiving, 2015 theft by taking, 2016 gun charge, willful obstruction in 2017, another theft by taking in 2017, possession of tools for the commission of a felony in 2018, marijuana WID in 2019, 2023 theft by receiving 2 counts. Also, he was simultaneously, I believe, booked in for a RICO charge and 8 felony counts of theft by taking here in Fulton County. So the request is, while I do understand that these likely will not be holding him, as he's probably still on a no bond status for the RICO charge and 8 felony counts, but we'd be requesting $1,000 on each count for a total of $2,000 surety bond, no alcohol, drugs, or weapons, a no contact with the listed victim and one of the accusations of Mr. James Ellis, James traditional spelling Ellis, Ellis, and a stay away from both incident locations as there are 2 separate locations. And if we could sound for Mr. Ellis in accordance with Marcy's law, that'd be greatly appreciated, but there's nothing further to add from the state at this time.
All right, is Mr. Ellis present? Wishes to make a statement briefly. All right, hearing none, Mr. Bartels.
Yes, thank you, Your Honor.
I'm sorry to cut off Mr. Bartel, but he got bond for all his felony charges.
He got what? I'm sorry.
He got bond for all his charges for felony.
Oh, he's not on a no bond. Okay, understood. Thank you.
He has bonds on the felony. Okay. All right. Thank you. Yes, Judge. I've spoken with Mr. Anderson. He does deny the allegations that he took these 2 saws. I'm a little bit confused in terms of an alleged victim being listed by name when it looks like these saws were on the property of Georgia State. I would argue that, the connection between any identification of Mr. Anderson and who may have taken these saws, it's fairly tenuous. The vehicle that was stopped, there were multiple people in this vehicle, and the description of having jeans and a hoodie and a black male is not very limited. So given all that, it looks from the paperwork like he may, I have a hard time reading, but with the new forms, but it looks like there is a check mark on a UJR pretrial level 2 release. We would ask the court to consider that. If the court is not willing to grant that, then we would ask, I think $1,000 bond for each charge would be reasonable in light of the circumstances if he doesn't qualify for a UGR. He is employed. I'm advised that he works for PAW. It's an art production company. He is an artist there. He is also born and raised in Atlanta, so he's lived in Atlanta all his life. And he does have his mother and other extended family in the area. So that's all we have at this time, Your Honor.
All right, understood. Defendant's going to receive a $2,000 surety bond. He's to stay away from both of those locations and have no contact with Mr. Ellis. Additionally, he's to have no drugs, no alcohol, no weapons. And he is also going to all purpose on the 3rd. Best of luck to you, Mr. Anderson. Who do we have next?
The quorum is empty. Your Honor, we can go to position number 7.
What about 4 and 9 before we go to the breakout?
4 and 9, give me a second. 4, bond was paid. Position 4, bond was paid.
Okay.
I'm sorry, was that 4 has already bonded out?
Yes.
Okay.
And number 9?
Position number 9 was the case that you were referring to earlier with the death by shoplifting.
No, theft was number 9. I have Todd, Nicholas Todd.
Yeah.
So actually we need to make sure that, so that was the case where the one on the calendar is a duplicate. So that needs to be dismissed. Also, he is in on a FTA for the one that was duplicated, but that shouldn't be a FTA because he did go to the clerk's office previously to set aside the bench warrant, update his address, the address that was in Odyssey now, and the address on the returned mail was the old address and not what he
Wait, so number
stated.
9 has already been handled and you're asking that it be NOD'd?
They took it off the booking screen altogether, Your Honor. He's not even in
Okay,
on
so
it.
all of those are
All the
gone.
way
Okay.
cleared
Is
off.
what is the new address in Odyssey?
Yeah, the new address is in Odyssey also.
Okay,
should-
all right, perfect. Thank you.
But those charges are cleared from Odyssey.
Okay.
Okay. All right,
All right.
let's go into the breakout for position 7, please.
Thanks so much.
Oh, before we do, I'm sorry, don't put us in there yet. Mr. Howard, will you put the history onto the record? You started for position 7, Mr. Shadrick.
26. Got to open simple battery 2 counts out of state court. 2023 ag assault dismissed. 2022 obstruction conviction. 2021 burglary conviction. 2021 vandalism. 2021 exhibit deadly weapon. 2020 battery obstruction conviction. 2017 vandalism conviction. 2015 disturbing loud music conviction. And 2014 petty theft conviction.
All right, thank you. Now, if we could go into that breakout, I'm sure Ms. Bronte, Ms. Reddick, if Mr. Bartels, any other parties that need to come, please use that raise
Yeah,
hand.
I can go to the breakout room too. Thank you, Judge.
All right. All right, defendant is gonna receive a $4,000 surety bond, 2,000 on the battery, 2,000 on the simple battery. He's to have no contact with any of the alleged victims in this case and stay away from that location. And I'm just talking and no one can hear me. My apologies. Defendant is going to, you can hear me. It muted for a second. Okay. He's to stay away from that location unless receiving mental health services, have no alcohol, drugs, or weapons. We are going to ask that a social worker visit him, and he's going to be reset to all purpose on the 3rd. Is there anything additional? All right. Best of luck to you, sir. That concludes your case. And I believe that concludes the entire calendar. Ms. Bridgewater, will you please review it for me?
Yes. Okay, the reset date for the SAP calendar once again is October the 3rd. Position number 1 is going to that SAP calendar with a total $2,000 good bond. Position 2 is reset further notice with a $2,000 SOB through the jail. 3, SAP calendar with a total $2,500 good bond. 4 is set further notice as the defendant has been released. 5 is reset further notice with a total $5,000 SOB through pretrial. 6 is going to the SAP calendar with a $1,500 good bond. 7, SAP calendar with a total $4,000 good bond. 8, SAP calendar with a total $2,500 good bond. And position number 9 is not on docket. Are there any questions, comments, or otherwise?
I do have a question.
That's it.
Okay.
Position number 9 is Mr. Nicholas Todd. How's he NOD?
It was
I know I didn't submit an NOD, so that's why I'm wondering how he's NOD.
There was an email about this earlier. I don't remember what happened, but apparently this was a duplicate of something else and it's been completely deleted.
the case that it's a duplicate of is 24 CR 000-879C. It's the exact same case, same date, same location, same items taken.
The judge, I wasn't a part of that email string, so that's why I don't.
Okay, that's fine. I just looked at it in passing. So, and to be honest, I just am taking the jail's word that it has been deleted and it's not holding him. So
Okay, so should I mark my paperwork just a duplicate? Would you feel
I think
best?
so.
Yeah,
I think so.
Joe was the one that told me about the duplicate, and then I was the one that looked in and saw that the FTA shouldn't have been an FTA either. So
Okay.
So
All right. I think we
guess
write
what I'll do,
duplicate.
I'll just
Write
mark it
duplicate.
as duplicate.
Write duplicate. That's what I
Okay.
would do. And I'll sign it.
Well, there's nothing for you to sign.
Oh, that's true. That's true. There is nothing for me to sign.
Okay,
That's
so
true.
I'll just mark the calendar as duplicate. And that should
Right.
take care of it, okay?
If not, I'm sure somebody will email me late tonight. Like I must be the one that people like to email late. I get lots of late emails. So I'm sure somebody will email me if this doesn't work out.
Okay, well, right now we're gonna mark it as duplicate and they'll get in touch with you.
All right.
Nothing else, and that's it.
All right. Take care, everyone. Enjoy the rest of your Saturday. Bye-bye.
thank you.
Take care.